Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. And in this video, we are here in 2022. I have decided to do something I haven't done in a while, and that's kind of update some of the core type videos that we do related to defending debt collection lawsuits, particularly those kind of lawsuits brought by junk debt buyers like Midland Funding, Portfolio Recovery, Unifund, all those kind of companies. So what I'm going to do is this week, I'm going to release 5 new videos that cover the basics when it comes to defending a debt collection lawsuit. I'm going to release a new video each day, and the first one today is going to be on drafting the answer to the debt collection lawsuit. Tomorrow we're going to release one related to compelling private arbitration as a way to get rid of the case. Then on Wednesday I'm going to release a video related to discovery and disclosure, how you should use that, and probably more importantly how you shouldn't use that. On Thursday we're going to talk about the big case killer for most people, the motion for summary judgment. And then on Friday we're going to talk about trials, how to defend yourself, and what some of the approaches and strategies are in trying to get rid of this junk debt buyer lawsuit for good. So this is going to be kind of a long one. We're going to stretch it out a full week. I appreciate you checking in here on day number 1. And if you haven't, please go ahead and subscribe to my channel. That way you'll be notified each day when I put out one of these new videos. But for now, let's go ahead and jump into drafting an answer to a debt collection lawsuit. All right, so something that's important to understand is why it's important, why am I doing this? Why am I refreshing these videos for 2022? And one of the big reasons is the whole really debt collection world landscape has changed. Just like with most things, COVID-19 has really impacted the way the debt collectors are doing business, but not in a way that you would think. I remember when the pandemic first hit in 2020, here we are, February, March 2020, everything shuts down. I do bankruptcy law. I practice law in Arizona, and the first thing I thought is the bankruptcy cases are going to go through the roof. People can't go to work. They're not going to be able to pay their bills. But something surprising happened. 2020 and 2021 were 2 of the lowest years for bankruptcy filings in the United States since the bankruptcy code was enacted back in the 70s. There were almost no bankruptcy cases being filed. And the reason why is because the federal government and some of the state governments came in with these stimulus payments and actually flooded the economy with cash. And what that did is it made it a situation where people could not only pay their bills, but some of them were able to even pay more. And in response to that, the debt buyers did what you would expect debt collectors to do. They filed more lawsuits. Encore Capital, the parent company of Midland Funding, one of the biggest debt buyers in the country, they admitted that in 2020 they filed more lawsuits against consumers than ever before. And so we're coming into an environment, and that's why I wanted to update these videos a bit, is because there are more lawsuits out there, more people are dealing with this. And also in places like Arizona, where I practice, the landscape's changed because some of the laws have changed. In Arizona, the homestead exemption was changed. And now judgments from a junk debt buyer act as a lien against your home. And so debt collectors in Arizona, we're seeing them be more aggressive than ever trying to get that judgment. I've cited to this statistic before. 95% of people who get sued by a debt collector don't do anything. They just don't respond to it. And if you don't respond to it, a default's going to be entered against you. Judgment will be entered in full, plus they'll probably throw in some attorney's fees and interest. And once they have their judgment, they can garnish wages, they can garnish bank accounts, and now in the state of Arizona, they can lien your home, and they can even force the sale of your home through a sheriff's sale. So it's more vital than ever that you avoid the default judgment, you draft an answer. It's not a difficult document. Of all the things you have to deal with in defending a debt collection lawsuit, this is probably the most basic and the simplest thing that you can do to give yourself a fighting chance. So what I want to do in this video is take you step by step what needs to be done, and again, more importantly, what doesn't need to be done. I highly recommend, if you're being sued by a debt collector though, and you need specific legal advice, contact an attorney in your state. While I am licensed in the state of Arizona, I'm not licensed anywhere else. I can't give you legal advice, and I don't know some of the kind of nuances that each state does have. I can just tell you some general information on what you need to look for. Contact an attorney, they can help you. All right, let's go ahead and jump in on how to draft the response to a debt collection lawsuit. Okay, so the first thing I want to do in the video is walk you through what a complaint is. The complaint is the document that's filed by the debt collector. Sometimes it's called a petition in different states, and it may look a little bit different from this, but this is just a run-of-the-mill lawsuit that was filed by Midland Credit Management, one of the sister companies to Midland Funding. So I think it's important to kind of navigate the document a bit. In the upper left-hand corner, you're going to see the name of the attorney's office that's handling your case. This one's handled by the Gerstel Law Firm. They're a big debt collection firm in Minnesota. They're here in Arizona. They do a lot of cases all over the country. So you're going to see their information there. This is important because you're going to be able to find like telephone numbers, email addresses, mailing addresses. Anytime you need to contact the other party, the opposing party, or send them documentation like the answer, you're going to be required to send them a copy. This is where you need to find it. If you ever want to reach out to them for settlement, telephone numbers, email addresses, those kinds of things are important. It's also important to understand that the party that's listed in the upper left-hand corner is not the party that's suing you. I mean, they're facilitating it. They're the hired lawyers that are doing it, but they aren't claiming that they're the owners of the account. That's who the plaintiff is. So sometimes I get people who get mixed up. They think they're dealing with a junk debt buyer lawsuit when they're in reality dealing with an original creditor lawsuit. They're just mistaking who this party is in the upper left-hand corner. That's just a lawyer. They're the hired gun that's been hired by the plaintiff to bring the lawsuit. Then if we go down a little bit further, you'll see in the middle here, this is going to show you which court your case is filed in. So, for example, this one's in the Pioneer Precinct No. 1 Justice Court in the state of Arizona, County of Pinal. Pinal County, just south of Maricopa County, south of the Phoenix area here, has the address, the telephone number. This is important because this is the court where your answer needs to be filed. Your jurisdiction may not require the address and the telephone number to be put there, but that's going to tell you where you need to look to be able to file your response with the court and then mail a copy to the law firm who's in the upper left. This whole portion up here is called the caption. So you'll see over here on the left, we have the plaintiff, who is the party who's alleging to have ownership in the case. In this case, it happens to be Midland Credit Management, Inc. as the plaintiff versus, and then the defendant's name. And it's going to have your name listed there if you're the defendant. Over on the right side of the complaint, you'll have the case number and then the title. Now, when you file your answer with the court, it won't say complaint there. You'll put answer. So all of this stuff will be pretty much the same, except for when you're drafting your answer in the upper left-hand corner, it'll have your name, your address, your telephone number, your email, that kind of thing. And then the caption is going to be the same, with the exception you will be filing what's called the answer. Then we see here, you're going to see some just preliminary language here. It says Plaintiff Midland Credit Management, Inc., by and through its undersigned counsel, and for its cause of action against the above-named defendant hereby states and alleges as follows. And then they go through some very general allegations. Paragraph 1, they're saying that defendant is a resident of the state of Arizona in the county of Pinal, thus venue is proper. Paragraph number 2, the amount sought by the plaintiff, hereby exclusive of interest costs and awarded attorney's fees, is less than $10,000. Then they get into more specifics in paragraph number 3. The plaintiff is the owner of certain accounts of Citibank, NA/Costco, Anywhere, Visa card by Citi, yada, yada, yada. And then they put account numbers, that kind of thing. In this particular one, they go into, allegations relating to community property laws in Arizona. If we look over on page 2, they actually start getting into their counts. These are the claims that they have against you. Count 1 is breach of contract. And like in paragraph 10, you'll see it says the defendant applied for a revolving credit card from Citibank, accepted the defendant's application, and issued to defendant its credit card with the account number ending in XXX kind of thing. And then they're going to, they go through here, get down to paragraph number 14. Defendant owes $4,705.78. They talk about that the money's been demanded, hasn't been paid. And then this last section where it says, wherefore, plaintiff requests the court to enter judgment against defendants as follows. Paragraphs 1 through 4, this is what's known as the prayer for relief. This is what they want the court to award them, which is the dollar amount here, the $4,705. They want their costs, they want interest, and then they want just further and additional relief. Sometimes they'll ask for attorney's fees here. So one thing to notice about the complaint is each of these matters, each of the allegations are in specifically numbered paragraphs. And that's important because when you go to draft your answer, you're going to you should get a copy of the complaint, and you should have been served a copy, so you actually have a physical copy, and you're going to go line by line, paragraph by paragraph, and admit or deny the allegations that they're alleging. Now, it's important here, actually, let me bring up what a typical answer would look like. So this is an answer that would be, I drafted here at my firm. You're seeing in the upper left-hand corner the information, how before it was for the debt collection attorney. Now this is for my law office. Jackson White is where I work. Email addresses, addresses, all that kind of stuff. The court, top of the caption, again, we have the same court. Then in the caption, we have the plaintiff, we have the defendant, we have the case number, and then we have the answer. So the answer is listed there so the court knows what kind of document it is. And then what I do is I go through each of these numbered paragraphs. So I'm having my complaint and my complaint and my answer, and I'm going to go through each of the allegations in those numbered paragraphs and state whether I admit the allegation, whether I deny it, or the third answer is if you don't have sufficient information, you can therefore deny. So if there's something that they're asking you and you're not 100% sure, you can say, I lack sufficient information and therefore I deny. So you'll see here in paragraph number 1, it can be this simple. In response to paragraph number 1, defendant admits the allegations therein. That doesn't mean you need to admit paragraph 1. I'm just saying for this particular defendant, they admitted those. In the same thing, in response to paragraph number 2, defendant admits the allegations contained therein. But then in paragraph 3, this defendant said in response to paragraph number 3, defendant denies the allegations contained therein. And we went through, and there were various ones that were denied, some were admitted. And you do this as well once you get down into the counts with the very specific allegations. Again, there's admits in paragraphs 10 and 11 here. This defendant admitted those allegations. But number 12 is one that I was telling you, like if you don't have sufficient information, you can let the court know that. In paragraph number 12, the response was, in response to paragraph number 12, defendant is without sufficient information to either admit or deny the allegations and therefore denies them. So you need to do that for each of the numbered paragraphs in the complaint. Now, that's really all you need to put as far as responding to those specific paragraphs. If you don't, what you want to be careful, the number one mistake I see people make, besides not filing an answer, is when they draft an answer, they include way too much information. They include information as far as why they went into default. They include settlement proposals that they are trying to do, or payment proposals. None of that is relevant and actually will harm your case at this stage. It's not needed. The court, from their eyes, they have a complaint with a bunch of allegations, and now they want to see in your answer whether you admit or deny what they're alleging. The court wants to see, is there a dispute between the parties? And so that's all you need to put. At this stage, that's all you need to put. All the other stuff can come later in the lawsuit, but at this stage, it just needs to be pretty simple. Now, you can also put what are called affirmative defenses. Sometimes these get a little bit confusing to people. Affirmative defenses in the civil world are the equivalent in the criminal law world of a defense like, if you shoot somebody and kill them, but you have an affirmative defense of insanity or self-defense. Self-defense is a little easier. So self-defense, basically what you're saying is, look, even if everything that the plaintiff is saying is true, there are some defenses I have that mean that I'm not going to be held liable. So again, in the criminal law context, you can say, yeah, I shot the person, but I have a defense. It was self-defense, so I shouldn't be held liable. Same thing in civil cases. The most popular one would be statute of limitations. Statute of limitations is where we are alleging that even if everything that the plaintiff is alleging is true, it's too bad. They waited too long. The statute of limitations has expired, and now they can't collect on it. And so you can put those in there. Here's my statute of limitations. I put defendant alleges for his affirmative defense against the claims of the plaintiff that the statute of limitations has expired. Then you can put a thing just saying we've responded to everything. We'd like to have all our costs awarded. You can't ask for attorney's fees unless you have an attorney. And then you have to date it, sign it, and then you have to mail a copy over to the other attorney's office. It's important to know that in most jurisdictions, the court does not mail the other party a copy. So you're responsible to do that, otherwise it can cause problems. So those are kind of really just the basics on how to draft the answer. Now, I have an online tutorial. I'll put a link in the comments section below, in the notes section below, where I have a template, and I go into a lot more depth as far as how you deal with each of these. But that's really the basics. That filing the answer is a relatively simple process. The court just wants to know, do you admit or deny what they're alleging? And one, you have to be honest. This is something you need to fully be honest in responding to. Two, if it's a junk debt buyer, if it's not a company you had a contract with and they haven't established what it is that they're alleging, it's okay to deny it at this point. If, for instance, if they're saying you owe $4,705 and you know that the account wasn't ever higher than $2,500, then you could honestly deny that. So make sure that you are providing accurate information to the court, but also make sure that you're not admitting something where you're essentially just guessing if it's true or not. So I hope that helps in drafting the answer. Like I said, 95% of people who get sued by debt collectors do not file an answer, and they end up with a default judgment, and that takes so many of your options off the table. So I hope that's helpful. Tomorrow in the video, we're going to talk about, instead of filing an answer, how you can actually request that the case be considered for private arbitration as a way to get rid of the case once and for all. Thanks for watching today.